Good evening. I want to thank all of you for taking time out of your busy evening to join us. My name is Michael Romig. I'm the owner of PG Fit, and several years ago, I had the privilege of training Julie and Jason Brower, and I got to know them very well. And we're really excited to have Jason as a presenter this evening. And this is something that I'm actually really passionate about. About 4 to 5 years ago, my wife and I, we decided we were going to make an effort to get everything in order in case something unexpected happened to us. And so I thought the best approach was to get onto LegalZoom and to create a will. And little did I know until I talked to Jason, until I actually went to one of his workshops, that I realized that I was not doing the right thing. And so I'm really excited to have Jason on the call with us tonight as he talks to us about the importance of estate planning. So without further ado, Jason, go ahead and take it away.
All right, thank you, Michael. I appreciate it. Appreciate you giving me the opportunity to talk. I want to welcome everybody that made it, and thank you again for taking time out of your day. I know it might seem like kind of an odd pairing when you think about estate planning and personal training. It doesn't always come right to you why those two go together, but actually it makes a lot of sense, and it made a lot of sense to me, and that's why I went to Michael and I said, hey, I think we can partner up, because a lot of what you do, what Michael does, is take care of your health and make sure that you are in the best health that you can and that you're physically fit. And going along with that is taking care of your affairs and making sure that everything is in order, not just your physical health, but also your other affairs, what you have at home, your assets, and making sure that you don't leave out what could happen later on in the area of if something happened to you, who would be there for you, who would take care of you. And so that's my job. I'm here to really talk to you about what estate planning is, what probate is, and what options you have. A lot of people hear the word probate, and what does that actually mean? What does probate mean? What's involved in the process? What happens to your assets when you're gone? Who's in charge? Who makes decisions? Where do they actually go? Who decides that? How can you make sure that it goes exactly like you want it to go? And then also, what are the different types of estate plans? What's available to you? What's your best bet? What does a will do? And in fact, why a will is not always the best option for you, and it's never enough by itself. A lot of people don't realize it, but a will is never enough. To have a proper estate plan, you have to have everything involved in it. And so just to give you a little background of who I am and why I'm talking to you today, obviously my name is Jason Brower. I'm an attorney. I'm an estate planning attorney. And with my wife, Julie, we have a probate firm, and that's all we do is probate and guardianship. We have over 30 years of experience between us, solely in the area of probate and guardianship law. We were trial attorneys for the first probably 12 to 15 years of our career. We did jury trials. I've done appeals. I've actually appealed cases all the way up to the Supreme Court. We're both certified as guardians and attorneys ad litem. And Julie was the founding partner of the state's only multi-city probate firm, boutique probate firm. And I've been voted as a super lawyer by Texas Monthly Magazine for the last 6 years in a row. And what that is it's an award that goes out to the top 2% of the attorneys in the state and just recognizes you for excellence in your field. So why am I here today? Well, I'm here today to talk about probate and to tell you that the real problem with probate is at the end of the day, there's no winners. Okay, what do I mean by that? Well, in probate litigation, even when you win, you lose. The reason being is that somebody has obviously died, and that's led you to be in probate court. And if you get stuck in a probate litigation case, at the end of the day, there are no winners. Let me give you an example. One of the last cases I had in litigation, a gentleman came to me and said, my father has died. He left a will. My mom died a couple of years before this, so she's already gone. It was just my dad. He lives with me. I've been taking care of him for the last 5 years or so. And he's left everything to me, and I have a will, and so I need to probate his will. Well, I looked at it and said, okay, this is great. Everything looks in order. The will was signed, notarized, everything looked perfect. So we filed the will for probate. I told him it'd be really simple, really easy process, no need to worry about anything. And we show up to have the hearing to probate the will, and his brother shows up. Well, his brother hadn't been around for 20 years. He lived off in California and was in the movie business. And he had mentioned his brother, but he said, don't worry about it. My brother hasn't been around in forever. He's got tons of money. He doesn't care. It's okay. Well, guess what? He didn't have tons of money anymore. He was broke, and he was going through a divorce, and he was looking for his half of the estate. So what he said was, there's no way my dad would have cut me out. You must have convinced him to do this. You must have unduly influenced him, or you must have taken advantage of his diminished capacity in some form. And that's the only way my dad would have cut me out, because I know I've been gone for 20 years, but no way. Dad said he'd always take care of me. So at that point, my client was distraught. He was beside himself. And we had to go home from court and without having a hearing that day, because the court said, okay, now that it's contested, we've got to put it on a whole new docket. We've got to come back. Everybody has to get lawyers. We have to have a trial. And so my client was upset, and I told him, look, don't worry about it. I've been a probate attorney for a long time. I know what I'm doing. This is a really, really easy case. This guy doesn't have evidence of undue influence. He doesn't have evidence of diminished capacity. He doesn't have any evidence at all. He's been gone for 20 years. He has no idea what went on. So I'm going to do something that's called a summary judgment proceeding. And what that is where I ask the judge, Judge, we can rule on this right now. We don't even have to go through a trial, because it's such a rock solid case that unless they can come forward with some evidence right now, then you can rule on this without a full-blown trial. Now, it doesn't get granted very often, but we filed it and it came back. The judge said, you won. So I was ecstatic. At this point, I'm thinking, Texas Monthly must be onto something here, because I guess I am pretty good. So I called the client, and I'm all happy, and I said, hey, guess what? We won. And there was dead silence on the line. And I said, hello, did you hear me? And I'll never forget it. He said, yeah, I heard you, but what did I win? I thought, well, what do you mean? We won everything. The court kicked it out. You can move forward with your will. Everything is in your name. It's all good. They kicked his side out completely. And he said, yeah, no, I know. I understand that part of it. But here's how I see it. I lost my dad, and obviously he's not coming back. Now I lost my brother, and we'll never get along again. And I just lost a quarter of my inheritance to you as an attorney, so that some judge could tell me what I knew before this, and that was that my brother didn't have a case. So remind me again what I won. Well, I didn't have a good answer for him. And so that day, I went to Julie, my partner, and I said, we've got to figure out a way to avoid litigation, all right? Let's put together an estate plan with everything we've seen over the past 20 odd years. Let's put everything together in one plan that we know can prevent all this litigation, that can take everything into account and have a contingency for it. And so we spent months researching options, and we came up with a new way of looking at estate planning. And it goes right along with what Michael does, because of what it is it's bodybuilding. It's really building a body, because the goals of estate plan are really to move stuff. You want to transfer your assets, okay? And what you need to move what you have to whom you want, when you want. It's not always just at death. People think estate planning is just, okay, well, who gets my stuff when I die? Well, it's not always that simple. Sometimes you want to give away things while you're alive, because it can save on taxes. It can help out beneficiaries before you're gone. There's a lot of reasons why it might not just be at death, but also the way you want, okay? And also at the most reasonable cost, obviously. So estate planning is a lot like bodybuilding, because to move things efficiently, you need strong muscles. Well, to move your assets efficiently, you need a strong estate plan. And estate planning is the process of building those muscles. You choose what muscle groups to focus on, and it's what's best for your unique situation. What type of assets do you have? What are we going to be moving? Do we have houses? Do we have land in other states? What do we need to move, and what do we need to build up in order to be able to move that? We put together a workout plan that gives you the tools that you need to move your stuff, all right? And it becomes a question of which plan do you prefer. Now, this is where I'm going to go into the different levels of plans and talk about what each does and what the problems are and what benefits there are. So let's start with level one. All right, level one is what I like to call the couch potato plan. All right, there's a picture of level one. Now, it's also the state's plan. All right, it's no longer in an estate plan, it's just the state's plan. What do I mean by that? Well, without anything in place. See, everybody thinks, oh, well, I have an estate plan, I've got a will, I've got a trust, I've got all the, I have an estate plan. Or you think, well, I don't have an estate plan, I don't have a will, I don't have a trust. Well, guess what? Even if you don't have a will, and even if you don't have a trust, even if you've never been to an estate planning attorney before, you have an estate plan. And the person that has put that plan in place is the state of Texas. They have a plan for you. So if you do nothing, your assets are going to get moved according to how the state of Texas wants to happen. And it is the most inefficient way possible. I know that's shocking that something that the government's in charge of would be inefficient, but there it is. It requires two of everything. It requires two attorneys, two hearings, and two sets of fees. Now, the reason for that is if you die without a will or without anything in place, the first thing the court has to do is decide who's in charge of moving your stuff. That's the administrator, and they have to appoint an administrator. All right, so somebody has to apply to be appointed. They have to prove up themselves that they're qualified to be an administrator. And once they're appointed, then the court has to determine who your heirs are. And you have to have another hearing where another attorney, an attorney appointed by the court who represents unknown heirs out there, determines who actually are your heirs and where do your assets go. And at the end of the day, you have no say over where it goes. You can see on the screen, there's a Texas Descent and Distribution Plan that lays out what happens when you die. And it's not always what you would think. A lot of times you think, well, it's probably what I would choose anyway. No, that's not the case, actually, because what can happen is if you have a blended family and you have children from outside the marriage, if you die, your assets immediately transfer to your children, even if they're minors. And if you have minor children and they inherit from you, they're required to get guardianships. And we'll go into that more in a minute, but it's a very inefficient plan, and it's something you want to avoid. And you have no say over who's in charge. You have no say over where it goes. And so you want to avoid that if all possible. That's the worst plan possible, is to do nothing and use the state's plan. So let's move up from that and go to level two. This is the most basic of actual estate plans, and that is the chicken legs plan. What do I mean by that? Well, I'm sure you've always seen people in the gym that are working their upper body and working their chest and their abs, but on leg day, they're a little too sore, they're a little too sick, or they've got work issues and they just don't hit the legs quite as hard. So you've got half a plan, basically. That is a will. Now, I know that shocks a lot of people because a lot of people are told, oh, a will is great. A will is exactly what you want. Well, a will is definitely better than no estate plan at all. But what is a will? Well, it's a legal document that passes title to your assets at your death, which sounds great, but how does it go about doing that? Well, that brings us to problem number one, probate. Now, you've heard me use that term. What most people think is that, oh, I'll never end up in court. I don't have to worry about that. I have a will. I don't have to go to court. Well, that's wrong, absolutely wrong, because if you have a will, you will end up in court. At least your heirs will end up in court. And that's because a will requires probate. Where there's a will, there's a way. And that way is through probate court. That's the only way with a will. See, a will is just a piece of paper until a court says it's a valid document. I'll give you a real world example. Let's say that I have a will and I leave everything to my wife, Julie. Well, if I die and Julie wants to sell our home, we have 5 children between us, so we have a pretty big house. And let's say that I die many years from now and the kids are gone and it's just Julie and she wants to get rid of the big house and downsize. And so she goes to sell the house and it sits on the market for a while and she can't sell it and she's getting desperate. And then finally somebody shows up and says, look, I love the house, I want to buy it, but I need to close in 30 days because I'm moving down here from up north and I've got to move in 30 days. The kids are about to start school. And so can you close in 30 days? She says, great, I can absolutely do that. I'll do whatever I need to do. And she runs to the title company and the title company says, okay, well, where's your husband? Well, she says, unfortunately, he passed away. And they're going to say, okay, well, you can't transfer your house because you purchased it during marriage. It's a community property asset. So no matter whose name's on the note, no matter whose name's on the deed, if you purchase it during marriage, it's both y'all's. It's half yours and half your spouse's. And so they're going to say, I need some proof that he left it to you. And she says, oh, wait, I've got this will. It says he leaves everything to me. That sounds great, right? Wrong. The title company is going to say, we can't do anything with a will. We need an order from the court that says that will is valid and that it's been admitted to probate. All right, so how do you get that order? Well, that's the problem. The probate process. What's the probate process? Well, it's a public lawsuit, and we'll get that in a minute, but you file against yourself after your loved one has passed that you pay for with your own assets to prove to someone you don't know that those are in fact your assets. Does that sound like fun? Well, no, of course not. It's not fun. And it's expensive and it takes a really long time, especially if there's multiple states involved or if you have property in other counties. Because if you have property in other counties or property in other states, you're going to have to file your will for probate in all the counties that you own property. And that becomes very expensive. So you double or triple or quadruple all your fees at that point. But also there's a loss of privacy involved because, like I said, probate is a public lawsuit. Everything you file with the court is on public record. So anybody out there with access to a computer can go online and see exactly what you own and that you're now gone and here's your spouse and they're sitting there with everything that was there, and they can call on them, they can possibly steal their identity. Even if it's just your neighbors down the street, I don't want my neighbors knowing what I have. And so that's one of the biggest problems with probate is it puts everything on public record. But there's also the risk of contest. Like I said with my first example, anytime you're in probate court, you open yourself up to a contest. And most people think it'll never happen to me. I don't have to worry about that. We get along. I'm here to tell you that I've seen more than I could count cases where people said, oh, it's no problem, everybody gets along. And then the minute somebody dies, all of a sudden, little things that wouldn't have mattered before suddenly matter, and people are at each other's throats, and it's a mess, and all of a sudden we've got a full-blown contest on our hands. And so you want to avoid that if at all possible, because trials are expensive. I used to charge $25,000 just for a retainer if it was a full will contest. And then at the end of the day, there are no winners. Like I said, even when you win, you lose. And all the attorney's fees get paid out of the estate. So whoever steps in, they're going to get paid, and there's less at the end of the day for whoever takes. So there are no winners. Even if you win, you lose. But the biggest problem with a will, and this is why I say that it's only really half a plan. It's like just working out your upper body and ignoring your legs, is that a will does nothing until you die. But what if you become disabled prior to your death? What if you were to have a stroke, or what if you were to get Alzheimer's or become incapacitated at some point? A will does nothing. let's go back to our example. Let's say this time I didn't die. I just became incapacitated. And the same thing, Julie wants to sell the house. Same scenario. She goes to the title company and says, I want to sell the house. And they're going to say, where's your husband? She says, oh, well, he's in an assisted living center. He's got capacity problems. He can't be here today. They're going to say, I need him to sign. And she's going to say, well, he can't sign. He doesn't have the legal capacity to sign. So what happens then? She's going to lose the sale if she doesn't have anything, because a will does nothing. She couldn't probate the will. I haven't died. A lot of people think, oh, there's a solution to that. It's called a power of attorney, right? You'll hear this from lots of people. You'll hear it from lots of attorneys that don't do probate. They'll say, yeah, power of attorney, that's your answer. Power of attorney is simple. It's a real easy document. You can find them on the internet for free. You can just download one and fill it out and sign it. And you can say who deals with your stuff if you become incapacitated. That sounds great, right? Wrong. No, the problem with a power of attorney is that there is no law that requires a third party to honor a power of attorney. So that title company is sitting there. If Julie goes to them and she says, wait, I have a power of attorney. I forgot, my husband drafted this a long time ago, and it says that I'm his agent if he ever becomes incapacitated. She's going to pull that out and hand that over to them. And the title company, and we see this more often than not, the title company is going to say, you know, that's great and all, but it's our policy that we don't accept powers of attorney. Now, why is that? Well, because like I said, powers of attorney are simple documents. You can find them for free on the internet. Anybody can download it and sign it. And title companies know this. Banks know this. Financial institutions know this. The more we go, the more people are realizing that anybody could produce a power of attorney. And so that title company is sitting there thinking, you know, I don't know Mr. Brower. And so I don't know if he signed this power of attorney, but I do know that I'm on the hook if he shows up tomorrow and says, hey, what the heck just happened? You sold my house from underneath me. And there's no law out there that requires me to take on this liability. Why would I do that? And they won't, and they're not doing it anymore. And so powers of attorney are really not worth the paper they're printed on anymore. And so what you're stuck with is problem number 2, and that's a guardianship. Now, what's a guardianship? A guardianship is a lot like the probate process. It's a public lawsuit that is filed by anyone who wants to make decisions for you. And literally the code says that a spouse, a child, a relative, or anyone interested in your estate. That's what the actual terminology in the code is. Anyone interested in your estate. They can file and ask to be appointed your guardian. And what happens is, if you're incapacitated, you're now defended by an attorney that you've never met and that you didn't choose, okay? And all the attorneys are paid by you, whether they win or they lose. If you have 5 kids and they all hire attorneys and they all file to be your guardian and they all fight it over, all of those attorneys get paid out of your estate, even if they all lose. Doesn't matter. That's the way the code reads. As long as they can prove good faith, as long as they can prove you needed a guardian and that they had good faith when they filed, then everyone gets paid. And the other problem with guardianship is, well, it's expensive. Obviously, you're paying for all the attorneys involved. 2 attorneys minimum. And people don't realize this, but the first thing the court does is appoint the ward, the proposed ward. That's the person who's subject of the guardianship. They appoint them an attorney. And who is that attorney? Well, it's this guy. You know, it's the judge's drinking buddy, or it's the judge's friend who has coffee, or it's the judge's campaign contributor. It's somebody the judge knows, and it's somebody that you don't know. And that attorney is going to charge your estate and get paid. And it requires a bond. Even if you do get appointed guardian, you have to be bonded by a surety company. So you have to pay for a surety bond, and they ensure that you won't run off with all the money. Even though the money could be half yours, it could be your spouse that you're getting a guardianship over, and it's half your money, it doesn't matter. The court requires that you be bonded. All of your actions have to be approved by the court before you do it. So everything you spend on your spouse that's incapacitated, you have to keep receipts for, and you have to account to the court at the end of the year. And you have to have an attorney produce the accounting. So you've got attorney fees running throughout the life of the guardianship. You've got accounting issues throughout the life of the guardianship. You have to account to every penny that comes into the estate and every penny that goes out. And you have to prove it up with receipts. And then all your actions have to be approved beforehand. You have to get an order from the court that says you can do things. Before you can spend any money, you have to ask the court's permission and have them say yes. And it's humiliating. A guardianship is very humiliating because the proposed ward has to be in court, and they have to sit there and listen to all their family members or loved ones testify as to why they no longer take care of themselves. Well, nobody wants that. That's a very humiliating thing. And again, it's a public hearing. So there's going to be courtroom evidence of unsound mind, and there's going to be filings on him that say this person no longer has their right mind and they can no longer take care of themselves. And again, anybody with access to a computer can log on to the clerk's website and read and see, oh, hey, Jason is incapacitated. He no longer has the ability to make decisions for himself. And now his wife's sitting there all alone by herself. Wow, I had to pay her a visit, you know. It opens up the doors for identity theft. And you have to produce an inventory of all your assets, file it with the court. What I like to say is, if you were going to hire me as an attorney, and I said the first thing I'm going to do is I'm going to ask you for an inventory of everything you own, and I'm going to take that inventory to the front door of my office, and so that anybody that's walking by my office can look and see exactly what you own and know that you're incapacitated. Would anybody hire me as an attorney? No, of course not. Nobody would. Well, guess what? If you file for guardianship, you're not just taping your inventory to the front door of my office. You're putting it on the internet for anyone in the entire world with access to a computer can see exactly what you own and that you're now incapacitated. All the annual accounts go on public record. They're filed with the court too. And every single year you have to return and show this is how much came in, this is how much went out. Well, there's got to be a better way than that, right? Well, luckily there is. That's the next plan. That's level 3. Level 3 is the beach body, okay? This is the more kind of plan that we're looking for here. The estate plan equivalent is a living trust. Now, why is a living trust better than a will? Well, it does everything a will does and more. It transfers all your assets when you die, just like a will, but it also gives you a spotter. It allows for someone to take the bar if you become fatigued. And it does all of this without court. Now, what I mean by that is, if you become incapacitated, you know, we said a will is only half a plan because it only deals with when you're gone. Well, what about when you're alive? Well, a living trust deals with when you're alive. You name who's in charge. While you're healthy, you're in complete control. It's business as usual. Everything's the same, and it's fully amendable and revocable. You can put things in, you can take things out, you can change it. You can change your beneficiaries, you can change your trustees, you can do anything you want while you're alive. But if you become incapacitated, you name who takes over. It's not the court appointing somebody to take over for you, it's your choice. You say that if I become incapacitated, I want my wife to take over. And she takes over automatically as your trustee, as your successor trustee. She doesn't have to go to probate court. She doesn't have to appoint an attorney to represent you. She just takes over and starts paying your bills, taking care of your needs, just like you would while you're alive, and does everything you want her to do, and you get to choose that beforehand. So it's a full plan. It works out your entire body. It does everything you need. Plus, it avoids outright distributions. And what do I mean by that? Well, the problem with outright distributions, what an outright distribution is with a will, typically what you have is you say, when I'm gone, leave everything to my spouse or leave everything to my kids. And that's in an outright distribution. It just goes, the executor is appointed by the court, and their job is to distribute your estate however the will says. If you say I split everything between my 5 kids equally, then the executor steps in, takes everything and splits it equally among the 5 kids. Well, what about what if your beneficiaries are too young? What if you have minor children? Here's an example. Look at this guy. He's way too young for all that money. And what happens is we're back to a guardianship. If a minor child inherits any money, the court will automatically set them up a guardianship. And we're back to where we were before, 2 attorneys, a very expensive process. The guardian is going to have to account every year. That's something you want to avoid. So if you have minor children, you don't want to leave outright distributions to them. But even if they're not minor children any longer, what happens if you give a 21-year-old a check? Let's say you give a 21-year-old a check for $100,000. Well, I'll tell you what's going to happen. Vegas is going to happen, and it's going to happen quickly. And that money, no matter how much you gave them, is going to be gone. And so outright distributions may be wrong, even if your beneficiaries aren't too young. Maybe there's a drug or an alcohol problem that you want to avoid. You don't want to fund any more problems with a beneficiary. You want to care for them. You want to give them things, but you don't want to make it to where they can worsen their problem. Or maybe the person is just not good at handling money. Some of our brightest clients, we have doctors who tell me, look, I just don't like dealing with money. I want to appoint somebody else to deal with it, and I don't want to think about it. Or what if you have a beneficiary who's receiving government benefits? When you're receiving government benefits, if you inherit money, it will automatically kick you off benefits. Well, you want to avoid that, and there are ways to do that. There's what's called a special needs trust or a supplemental needs trust. You might have heard these things. That's a way to supplement what the government gives you, to allow for the benefits to keep coming, but just pay for things that the government doesn't pay for. But let's assume none of those problems exist. If you provide outright distributions, you may still be wrong, and here's why. The number one way that beneficiaries lose their inheritance is through divorce. And a lot of people don't think about this, because what you'll hear is, oh, that can't be right, because inheritance is separate property in Texas. And if you have separate property, that means that if you get a divorce, your spouse can't take it, it's yours. Well, that's true, but a beneficiary spouse can take it if it's community property. And how does that happen? It's called commingling. When you commingle separate funds with community funds, the law says that it's going to presume that everything is community. So if you inherit money, if I were to inherit money today, I would have to go to my wife and I would have to say to her, honey, I'm going to put this in a separate account. And it's going to be just my account. Your name's not going to be on it. And it's going to be a separate property account. And the reason I'm doing this is not that I don't trust you, but I don't trust you. I don't know what I would tell my wife. I wouldn't have an answer for her, and she'd probably leave me right then. But usually what people do is they just put it in an account. You get an inheritance check and you just put it in your account. And as the minute you've done that, you've commingled it. And when you commingle it, the government says, we're not going to get in there and see which dollar is separate and which dollar is community. We're just going to assume it's all community. And then when you get a divorce later on, guess what? It's half. It's half hers, it's half his. It's all gone. Joint bank accounts are examples of this. But also, it doesn't even take a joint bank account. What if you take that check and you say, oh, honey, let's put on that extra room we've been talking about forever. A house is a community property asset. If you pay for that with separate property funds, you've created community property from separate property. When you get a divorce, half of that is gone. A new car, a lot of people get that inheritance check and say, oh, right, now we can buy that new car we've been thinking about. Well, that new car is community property. Anything you purchase during marriage is going to be considered community property. A new pool, same thing. Then all of a sudden, you come home one day and you've got the secretary, Tootsie Latour, and she's driving that new car, and your husband informs you, oh, honey, guess what? I'm getting a divorce and I'm leaving with my secretary. Well, she's going to get half. And now everything you left, let's say I leave my estate to my daughter, and I think, okay, her husband's great, they get along fine, I don't have to worry about anything. This is what a lot of people do. They say, oh, our kids are great, they get along great, I don't have any worries. Well, then later on they get a divorce, and I said it goes to my daughter. Now half of it's going to her spouse through a divorce, and it's funding Tootsie Latour, his secretary, and her 5 kids from 6 different guys, and all these people I don't even know, I'm now funding their inheritance. I don't want to do that. I want to make sure it goes where I say it goes. Same thing with the ladies, not to pick on guys. I mean, all of a sudden, Biff the pool boy is getting something. Say that you had a son and he was married Now suddenly his wife's running off with Biff the pool boy. Same thing. I don't want to fund Biff the pool boy's kids from other women. I want to make sure it goes to who I say it goes to and stays where I say it goes. And even if none of that happens, even if it doesn't happen, they can still lose it, because one thing people don't think about a lot is if there is a divorce and the ex-spouse files bankruptcy, creditors don't care. Even if the spouse said, "Look, I screwed up. I cheated on you with the pool boy, or I did whatever, and so I'm going to take on all the community debt. I'm going to say that I'm in charge of it. I assume all the debt." And then they filed bankruptcy right after the divorce. Those creditors will look and say, "This was a community property debt, so we can go after the community. We can go after both sides." And they don't care what the divorce decree says. They'll sue both sides and try to get their money from anybody they can. So now all of a sudden you've lost your inheritance to creditors from your ex-spouse that they got to write off in bankruptcy and you didn't. It's an easy way, and it happens all the time, and it's why outright distributions are wrong, even when beneficiaries are capable of handling their own inheritance. So instead of outright distributions, what a trust does is it says each beneficiary gets their own trust. It goes into what I like to think of as a vault for them. That trust owns their asset, legally owns it. So the beneficiary can control it. If you don't have any worries about them with money or anything like that, you can say that beneficiary is in charge of their own trust. That way they can spend it for what they want. They can decide how it goes however they want, but the beneficiary doesn't legally own it. The trust does. And those legal walls are what makes that protection. That way, if somebody sues them, they can't take it because the trust owns it. Or if somebody divorces them, they can't take it because the trust owns it. And a beneficiary's trust is standard equipment in all our living trusts. It's what we put in our living trust package. But not only that, and this is why I say that a will is never enough, because it's not just about taking care of your assets when you die. A living trust package includes the trust, but there's also beneficiary trust, there's tax planning involved, and I know that a lot of people will think, well, we don't have a taxable estate, because right now the taxable estate level is at about $5 million, give or take. And they think, well, we don't have $5 million each, and so we don't have to worry about that. Well, obviously, Trump has talked about maybe reducing that, and that sounds great because people think, oh, well, then I really won't have to worry about it because there won't be a tax level. Maybe there won't be a state tax at all. That sounds awesome, right? Well, yes and no. If you can make sure you're going to die during that time that there's no estate tax, then sure, that's great. But if not, what happens when a Democrat gets elected the next time? The first thing they're going to do is reestablish an estate tax. And probably what they're going to do is lower it way down from $5 million to the levels that it used to be at, something like 100,000 or 600,000 or whatever they want, depending on how long it was out there. It'd probably be lower regardless of how long it was. And so maybe you do have a taxable estate because we can't say what that level is going to be when you die. So tax planning is something you have to think about no matter what the current level is, because again, we don't know when that's going to kick in. So also, powers of attorney, durable financial powers of attorney, like we said, powers of attorney don't always work. The reason we put them in the trust package is because it's like a safety net that says if I left anything out of my trust and I become incapacitated, what I want is my trustee to be able to sign it over back into the trust. And then they go back to acting as trustee. It's really just a safety net. But we also give you a pour-over will as well. The will, like I said, a trust does everything a will does, so you don't need a will. Well, a will, our pour-over will say, if I left anything out of the trust, again, a safety net, pour it over back into the trust. If I didn't realize I had a piece of property out there and I didn't account for it, well, I want you to make sure it goes back into the trust when I die. So it's just a safety net in there just in case you need it. But we also do medical powers of attorney. Now, medical powers of attorney are different than financial power of attorney. They are good to have. They tell your doctor, if I'm incapacitated, this is who you talk to. If I need emergency surgery, I want you to talk to this person here, and I want them to authorize it for me. but we also give you physician's directives. Physician's directives say, look, if I'm in a vegetative state and I'm either brain dead or I'm going to die, and even given all medical treatment available, I'm expected to die. Either I want to be kept alive artificially or I don't want to be kept alive artificially. That's a physician's directive. We include those in our trust package. We also include HIPAA authorizations. HIPAA authorizations tell your doctors who they can share your medical records with, and only who they can share your medical records with. And then we also say that we give you free maintenance for life. What I mean by that is when you get a trust with us, you can come back anytime and say, I want to change it, I want to add somebody, I want to take somebody out, and all that's free. We just throw it in for free. And that's why I say a will is never enough. We do way more than a will at our firm. We say we cover all your bases, all your medical bases, all your financial bases, everything. It's not just an upper body plan, it's a full body plan that covers anything that could come up. Now, and this is really something that only my firm does. I don't know any other attorneys that do this, but if you were to get an estate plan with us, we say we give you free phone and email support for the life of the trust. So if you ever had a question, you can call us. One of the things we hated the most about doing litigation was that you have to charge by the hour. And so at the end of the month, we would send out a bill and a client would call me and say, I can't believe you charged me $50 for a 5-second phone call. And I'd say, yeah, no, I'm sorry. That's what we do. We charge by the hour. We have a minimum requirement, and that's just the way it is. Well, we don't ever do that. We're not ever going to start the clock running. You could call us at any time and say, hey, I just have a question about this, or I have a question about that. We're never going to send you a bill at the end of the month. And we're always there to answer questions or help you out if you need anything. And then we also give you notices for seminars. And if a law changes and you need to update your plan, we'll send out an email and say, hey, look, we need to update everybody's plan. Come in, let's set up a time. All this is free. And then usually we say every 3 years, come back in, check the estate plan. Let's make sure nothing's happened. Let's make sure nobody's changed addresses or changed names or anything like that. And again, all that comes free. So just as a quick review to talk about really what the types of plans are. The lowest level plan is, like I said before, have no estate plan. When that happens, it's the couch potato. Do nothing and be completely unable to move your assets like you want when the time comes. The state's going to decide everything for you, and you're going to pay double for that. You get to have no say in it, but you also have to pay twice as much. Well, that's a terrible plan, obviously. And then the second level is the will package. That's like a half a plan. It's just the let's skip leg day every week plan. It looks great at first, but it only works after you're gone. It leaves a huge half open for when you're alive. It does nothing. And so not a great plan again. And then the top level plan is the living trust. And the reason the living trust is a better plan is because it covers everything. It covers all your bases. It's there while you're alive, and it's there after you're gone. And it does everything a will does, but more, and it avoids court. It does all of it without court supervision. It really saves you money and time and frustration, and you can change it. Unlike a will, where the problem with a will is you have to basically redraft a whole new will if you ever want to change anything. You can do a codicil, but a codicil is really just a mini will. The code says it has to be done exactly like a will. Anytime you have a will and you want to change it, you're basically stuck doing a whole new will. Well, with a trust, you can just amend the trust and add anything in, take anything out. You can really, it's a lot more flexible than a will. And like I said, with my firm, we don't charge for any of that. So we give you that for free. Now, the real recipe for disaster is procrastination. That's the one thing I can't help you with. If you procrastinate, you're going to be stuck at the end of the day, because I can't go back and make a decision for you. And so our biggest obstacle is trying to get people to not procrastinate. I know estate planning is something that a lot of people don't like to think of. You don't want to have to deal with it. Nobody likes to think about getting sick or dying. But if you don't, you're going to be sorry, and a lot of people are going to pay a lot more than they have to, both in time and money, because you didn't put a plan in place beforehand. So let us help you avoid that. And that's why we say we give free consultations. If you want to come in, if you want to call us and just come in and sit down and talk, we'll talk to you for free. I really see it as my job to help you as much as I can to understand the process and feel as comfortable as you can. So I don't ever charge by the hour. I just say, look, come in. There's no cost. There's no obligation. You don't have to sign up for a plan. I'm just here to help you. I can explain even more about other types of plans out there. We have asset protection plans if you're worried about maybe asset protection issues. We have more in detail tax planning, anything like that. Just come in and we'll talk to you. And then because you're a client of Michael's, because you're doing so much to take care of yourself, we want to give you discounts for that. We want to acknowledge the fact that you attended this webinar, or maybe you're watching it later online. So mention that and come in and we'll give you a discount. And we'll say, look, we want to do everything we can to make it as easy as possible for you to get a plan in place, because it's really that important. It's something that you have to think about. So that's the presentation. If anybody has any questions, I'm here. I'll take any questions. I'm not sure exactly how Michael wants to handle it, but I'm here. I can answer anything. So,
Jason, this information is so important. I think, one of the best decisions that my wife and I made was coming in to see you and to set up a living trust. And I really want to thank you for taking time out of your busy schedule to do this. We're going to send this information out to all of our clients and to our newsletter subscribers. But thank you again for, like I said, taking time out of your busy evening to join us. So we're actually not going to do Q&A this evening, but again, thank you very much for joining. And if you do have any questions, feel free to email us. Or you can call us at 832-303-7004, and we'll make sure to get you in touch with Jason Brower. But Jason, if they want to go directly to you, where can they email questions or call?
They can visit our website. It's browerandbrower.com, and that's spelled out A-N-D. It's BROWERANDBROWER.com. Or they can email me at jason@browerandbrower.com, or they can call us. Our number is 713-280-9132. Just give us a call anytime or email me. I'd love to answer any questions you have, and I'm here pretty much every day. So.
Great. Well, Jason, thank you again for joining us, and please reach out to him. Thank you very much for attending.
Thank you.